As we head into 2026, law continues to shape the Israeli and Jewish experience in ways both expected and surprising. And it's not just because Israel has more lawyers per capita than anywhere else on earth. Legal battles are the front lines where culture, identity, and power collide. And whether it's existential constitutional clashes over who gets to define the state, international efforts to criminalize Israel's self-defense, or the creative ways Jewish communities abroad are using legal tools to push back against rising anti-Semitism, law is the battlefield and the blueprint. This show will keep tracking it all. But to start this year off right, I want to give you something different. Not a headline, but a lens, a key. One big idea about Israeli law and politics that will unlock what you're reading and help you cut through the clutter. Most people miss it, most coverage mangles it, but once you get it, it changes how you see the whole landscape. So let's get going. Now let's say you've opened your favorite non-JNS English language news site, if such a thing could ever exist. And at a top-line level, you probably already know. The press generally does a poor job reporting on Israeli law and politics. There's a huge amount of baseline knowledge required to understand what's actually happening here, most of which is conducted in Hebrew, and too little of it ever makes the jump into English. Partly that's because the clashes between the politicians and the attorney general and the courts generate attention. Partly, it's because technical constitutional debates are rarely newsworthy in real time. And partly, it's because much English language reporting on Israeli law resembles Hebrew language reporting on American law, loud on conclusions, thin on structure, and short on background research. Now, without explaining what powers the court actually holds or the checks that exist or don't exist between branches of government, or mentioning the decades-long debates that preceded particular rulings or reforms, what you get is a simplified narrative. The court said this, the attorney general said that, the politicians protested, and they did a thing. But these moments are not occurring in a vacuum. They sit on long-standing political and cultural fault lines. Years of unresolved constitutional tension, repeated and often failed reform efforts, and an extraordinary and largely unlegislated expansion of judicial authority. So I'm going to give you a small example of the knowledge gap and then a big one, which could figure prominently in the news in the coming months. So stick with me because this coming story is pure gold. Now, when the coalition first took power, a number of bills proposed by Haredi parties sparked outrage, and some undoubtedly should have. One was so over the top it was clearly meant to irritate. The idea was that if you own a dog in Israel, you pay a small registration fee annually to the city, right? That's already happening. But United Torah Judaism MKs Moshe Gafni and Ori Maklev proposed raising the fee from 50 shekels a year to 3,500 shekels. So if you have one dog, you're paying 3,450 shekels more annually. And if you have two dogs, it's 7,000 shekels, basically, and so on. Now, the alleged justification for the proposal was that the dog's carbon emissions, along with plastic bags used to clean their waste, harmed the environment. And according to at least one article, proceeds of the fees would allegedly be earmarked for reducing the street cat population in Israel, which, if you've been here, you know is quite plentiful, and for those who like cats, adorable. Now, the reaction to this bill was immediate. MKs rushed to assure Israel's dog owners, myself included, that Scooby-Doo was safe and that the bill was dead on arrival. Now, the thing is, of course it was. It was never meant to pass. It was just revenge trolling. You see, under the Bennett-Lapid government, the coalition preceding this one, taxes on disposable goods were raised in the name of good environmental policy. Now, Haredi families are larger on average, and they were disproportionately affected, and their representatives were resentful. Coincidentally, or not, Haredim are also a society that doesn't own dogs, whereas more religiously liberal and traditionalist and secular Israelis do. We love them. And this bill targeted the political base of the parties that had made everyday household items more expensive. That's the story. It was just pure, sheer high school hazing using the mechanism of the legislature to send a message. And it certainly wasn't about the Haredi entry into the climate change battle by way of Snoopy. So there's an interesting conversation here about competing social priorities, about the often unserious nature of Israeli lawmaking, and, by the way, also the extreme centralization of power at the national rather than the municipal level. I mean, why is the Knesset, the national state government, legislating something this granular, theoretically, to begin with? Now, in practice, it's because the National Ministry of Agriculture regulates registration fees across the country, and many, if not all, city fees and fines are ultimately authorized, in the bottom line, by national laws. That is a pretty wild concentration of power, as I said, and it's something that we should discuss another time. But the point here is that the press took the easy bait, and the story became even sillier in English than it had been in Hebrew, where at least it came with some cultural context and political memory. Okay, now we're going to turn to something far more consequential than puppy payment. And because we're going to talk about around legislation currently under consideration, I should say up front that what interests me here is the integrity of the discussion and not the endorsement of specific bills. The Israel Law and Liberty Forum, which I run, is an educational organization devoted to enriching legal discourse. And while we promote conservative and classical liberal approaches to law through debate and scholarship from Israeli law schools on up, and this is something that is sorely missing in Israel and, in my opinion, vital to its future, we don't endorse candidates, politicians, or legislation. What I say on this show is my opinion alone, but I do try to be careful. Now, we talk about ideas, and so that's the level at which I'd like to hold this discussion with you. Okay, a number of bills have recently been introduced proposing ways to split the office of the Attorney General. Now, the problem of the Attorney General's power is not new. The office has become so powerful that rather than advising and assisting the executive, often it operates as its own unaccountable check on the government. And this stems from an accumulation of contradictory functions over time, like both advising the government and overseeing the state prosecution. So before we even get to the issue of right-left politics, those roles are fundamentally different things and they require different expertise. And no single person can realistically perform them well. So that's why, for example, even in 2003, Minister of Justice Lapid, not Yair, but his father Tommy, was working on this issue. I mean, the first government committee to try sorting out the authorities of the Attorney General and to whom he was subordinate was in 1962, and that was the Agranat Commission. There was another in 1997, the Shamgar Commission, by which point the Attorney General was even vastly more powerful than he had been. So there are professional arguments and old arguments that simply aren't being aired right now in the discussion about these bills and the reform to the office generally. Now let's move to the political questions. The Attorney General has court-endowed powers to determine what is legal for the executive, to serve as its exclusive representative in court, and to bar outside representation. Now that means that there have been cases in which the government is sued, and the government's own position is simply not argued in court. Now, in addition to those superpowers, the Attorney General, as I said, oversees the state prosecution, and therefore he or she holds the power to decide whether to investigate and prosecute public officials. What effect does that have on a government's ability to advance policies that it believes serve the public interest? Can you work with someone effectively if you disagree with them on policy, but they can decide your political life or death? Now, a famous example of this kind of conflict in the job, I'm going to go back in time to show how old this issue is called the dollar account affair, and it took place in 1977, I think. The story involves Aharon Barak and Yitzhak Rabin during Rabin's first term as prime minister, when Barak served as Attorney General prior to his rise to the Supreme Court. Yes, he also served as the Attorney General prior to rising to the Supreme Court and prior to becoming the president of the court. He figures in pretty much all the stories about the expansion of Israeli legal power in one way or another. Now, at the time, holding foreign bank accounts was largely prohibited. Rabin and his wife had two accounts in Washington, D.C. The amount, I think, in each together totaled $20,000, and they had been opened while Rabin was serving as ambassador. Now, Leah Rabin, his wife, claimed that she solely used these accounts, although both their names were on them. Now, under normal circumstances, the accounts could have been closed and the Rabins could have paid a substantial fine, and this was in fact an option offered by the Minister of Treasury. As to what happens after that, there are a couple of versions of the following story, but they basically boil down to this. Barak, who wore the hat of the Attorney General, meaning he was the advisor to Rabin and potentially his prosecutor, effectively gave Rabin a choice: resign from office or face prosecution with potentially severe criminal penalties, in part, he argued, because public officials should be held to a higher standard than the average citizen. Now, Rabin resigned, possibly tipping the 1977 election in favor of Menachem Begin. By the way, Barak still chose to prosecute Leah Rabin, and both Rabins did pay a fine. Rabin's dislike of Barak is legendary and probably for another time, but the episode illustrates the problem of one person serving simultaneously as advisor and prosecutor, and there are a ton of other stories that cross the right-left divide. Zooming back to the present, we have these proposals moving through the legislative process. Now, the leading proposal as of this recording is basically a recycled bill of a proposal that was put forward by Gideon Sa'ar under the Bennett-Lapid government, which had committed to advance the law. Yeah, that's right. Not this coalition. A coalition whose leaders had acted forcefully against the recent judicial reform was on board to address this problem because it is simply so clear to so many and so punishing to good governance. We won't go deep into the mechanics of the bill, the split office and the approval committee, and that's because details can change quickly, proposals can change quickly. There are lots of compromises and negotiation and horse trading prior to final votes. But the core concerns that it addresses are familiar: inherent conflicts of interest in the office, limits of expertise, and the concentration of immense authority in the hands of an unelected official, plus a unique veto over government action. These are not partisan complaints. They go back to questions of institutional design. Now, the Attorney General's office has submitted a legal opinion opposing the proposals, and it shouldn't shock anyone that the Office of the Attorney General has concluded that splitting the authorities of the Attorney General would deal a mortal blow to democracy, whose integrity, it argues, rests in part on the Office of the Attorney General. Now look, the submission of an opinion is warranted, but there are two aspects missing to the discussion in the memo and the reporting on it. The first is the issue of the conflict of interest, and the second is a deeply necessary historical perspective. So we'll go into both. The conflict of interest should be pretty clear. This is an office opining on legislation that would reduce its own power. Now, perhaps that's normal in a system where 20% of the sitting Supreme Court justices sit on the Judicial Selection Committee, and where that same court will soon hear challenges to reforms affecting it. But even so, anyone acquainted with human nature should at least ask how that conflict could affect conclusions in the memo. The 37-page memo argues that splitting the office would basically dismantle it, subordinate legal advice and prosecution to politicians, strip opinions of binding authority, and turn legal advisors into something like private lawyers for the government that they're meant to be advising. It does acknowledge the current system's international uniqueness, but it insists that the uniqueness is essential to this Israeli governmental regime. And it warns that the split will bring the politicization of the public sector, rights violations, harm to press freedom, election meddling, and all manner of other democratic death strikes. It also questions intent, suggesting that the proposals are part of a broader effort to sideline the current Attorney General after the government has concluded that it hasn't been able to remove her in any other way. Now, this framing of the memo and what the Attorney General has said has dominated press coverage rather uncritically, certainly in Hebrew and to some extent in English, although the very notion that democracy relies on unremovable, concentrated power which is unaccountable to the public is one that defies the very definition of democracy. But I will say that underlying this all, there is a complaint articulated in the memo and by others who criticize the current legislation, and that runs through a lot of what we saw during the reform period too. It's a fear of an overly powerful executive branch with insufficient checks. And by the way, conservative scholars care about that issue as well. And while that concern is for another episode, just because it will take so long to discuss, it deserves real mention and consideration. For some, the complaints against splitting the AG's position or against this government doing it boil down to these concerns that there is insufficient separation between the Knesset and the government. Now, because the executive is comprised mainly of ministers who are taken from the Knesset, and because the Knesset itself is overextended and not fulfilling its oversight functions well, there are a few schools of thought that worry that the government just simply doesn't have sufficient checks. But that's a problem that could be addressed in many different ways. And the way it goes is that more conservative or classical scholars tend to favor strengthening the parliament in relation to the government, maintaining that firm linkage to democratic accountability and self-governance. And those in favor of judicial supremacy, who not coincidentally also favor often the sociological and political orientation of activist judges, believe that the government's ultimate check is basically a judicial super government. That's the way to go. As I said, it's a whole nother episode. But I want to conclude in our final minutes with the historical perspective that you need to understand what's coming down the pike. I've already mentioned that the discussions about the authorities of the Attorney General are old stuff, but they grew much more frequent after the court turbocharged the office's influence over the executive in the early 1990s. To give an example of one well-known, straightforward piece of writing on this, in 2009, world-acclaimed Israeli political scientist, Israel Prize winner, and former diplomat Professor Shlomo Avineri published a particularly famous Haaretz column titled Enough to the Concentration, or Stop the Concentration, Dai la Rikuziyut. And in this piece, he argues that the legal advisor holds powers, quote, with no parallel in any democratic society, and that the unelected nature of the position only increases the damage to democracy. He described a system never created by legislation, but by practice and rulings dating back to the colonial mandatory period, court decisions, committee recommendations, and the Attorney General's own declarations about his power, as well as aggressive expansion of the office by forceful personalities. His solution was simple, although the devil is always in the details. He said, make order. Separate the functions of Attorney General and State Prosecutor with safeguards for keeping their independence. Splitting the functions, he argued, is not a threat to democracy. The current concentration of power is. Now, the piece is one of the simplest and most well-known pieces of writing on this issue because of Professor Avineri's profile. And just so there's no confusion about what that was, Avineri was a brilliant man who called balls and strikes as he saw them, but he was very much a man of Israel's left. And you can find similar arguments from people affiliated to different parties with different worldviews, including from Professor Daniel Friedman, who was a former Minister of Justice and an Israel Prize winner, from Professor Gad Barzilai, who headed the law faculty at Haifa University, and from Professor Yedidia Stern, who was previously among the leadership of the Israel Democracy Institute and currently at the Jewish People Policy Institute. And these are all central figures in Israel's legal establishment. Serious debate has existed for decades, including in scholarly symposia and public forums, and they're easily accessible to any reporter inclined to look. But I've yet to see the fullness of this issue and even a small part of it actually presented in English. To frame what's happening now as an election year power struggle, which is often what happens, and which makes some sense, is really to flatten Israeli legal history and to distort its future. It also gets in the way of building the consensus that we need to move forward. We need to elevate from the politics of personality and lay the groundwork for the next century of Israeli flourishing. And this issue is part of the equation. That doesn't mean the proposals right now are necessarily the, quote, right ones. And that doesn't discount that lawmakers holding a political mandate should govern responsibly, with an eye toward moderation and compromise. But if we do get there at all, the correct outcome will come through that negotiation and democratic process, not slogans or fear. Now, when I say that, by the way, inevitably somebody says, well, what if democracy produces an undemocratic result? What if the Knesset, for instance, votes to kill all the redheads? By the way, that's an example that Israelis frequently use. Don't ask me what. But as someone with a personal stake in saving redheads, all I can say is that at that point, your society has problems that no court can solve. And by the way, such egregious outcomes are far harder to achieve in a fragmented coalition system than through sweeping judicial decisions. So, let's end on a hopeful note as we enter 2026. This generation, the one that fought in Gaza, that showed up when it was called, that has absorbed so much loss and sacrifice and economic strain and family strain and professional strain to defend this country, is not naive about power or allergic to responsibility. It understands that institutions matter. It understands that legitimacy matters. It knows that democracy requires more than good intentions to work. So if we resist the urge to chase the sensational and insist instead on substance, we too become participants in this great story rather than simply spectators. And God, it's a great story. Israel is a place of ingathering and rebuilding, of heroes and entrepreneurs and huge families and tight communities and tradition and innovation. This place is lightning in a bottle, and we just have to keep the bottle together. That'll take effort, but that's what we're here for. This generation and all of us with it will help write the next chapter of Israel's story. I want to thank you for a great inaugural year for Basic Law. Hope we have another. Happy New Year.